Well, let's start a round of follow-up comments with 5 minutes each. We'll go in the same order. I think to kick things off, I think it's fair for our judges to vote on if you work in D.C., you're impliedly from D.C.
I live and work in D.C. I think the focus on Chamber of Commerce versus Brown it doesn't really tell us much about preemption in the product liability cases. There is a separate jurisprudence about preemption in the labor context going back a lot of years that I think explains why there can be implied preemption. Justice Stevens can find implied preemption in that case and not in Wyeth, for example. The presumption against preemption that was mentioned by two of my colleagues here, I like the presumption, but I have to say I think you'd be hard-pressed to find a case in which it really affected the outcome. Typically, Justice Stevens is writing a decision in which there's going to be no preemption. He mentions the presumption. Justice Scalia is writing a decision in which he is going to find preemption. He does not mention the presumption. I like it, but I think all the energy that particularly you'll find in amicus briefs in the U.S. Chamber of Commerce arguing that there should be no presumption, it's just sort of a waste of energy, I think. One big reason that manufacturers argue that preemption is important is that it's very important to have uniformity, and they just can't be subject to laws of 50 states in addition to whatever the FDA is doing or whatever NHTSA is doing or whatever the Consumer Product Safety Commission is doing. And I think that's really a red herring. The tort law, first of all, has coexisted with product liability law. In fact, pre-existed with the regulatory state and pre-existed regulation by NHTSA, by FDA, by the other agencies. And I think that the fact that we didn't see much implied preemption arguments until 2001, really, when it took off, though there were some earlier, is illustrative of the fact that there's not really an implied preemption problem. The role of regulation, going back to where I started an hour ago, really is with a regulatory compliance defense. That is compliance with FDA standards or NHTSA standards or the Federal Railroad Administration standards. Does that tell the jury or the judge that what the company did was reasonable? Would a reasonable company have done more in light of NHTSA's passive restraint standard, for example? And that's the proper role, I think, for regulation in a tort case. I just want to finish by saying that this is not just an academic issue. There are real consequences to decisions holding that plaintiffs can't litigate their cases. First of all, most obviously, there is no federal tort law. If a plaintiff cannot pursue their state law claim, whether in state court or federal, there is no avenue through which they can receive any compensation. But the costs still remain. Either the plaintiff's going to pay or the government's going to pay or the insurance company is going to pay. But the cost to the family doesn't go away. In addition to which, tort law is an important source of information, not just for the plaintiff's lawyer, but for society, for the agency. In the Vioxx cases, for instance, the agency got a fair amount of information about what Merck was doing through the discovery that the plaintiffs took that they did not have access to before, which is entirely separate from whether or not the plaintiff should win or lose those cases. The tort law is also an important aid to inadequate agency regulation. The agency's ability to do a good job waxes and wanes over time with the vagaries of congressional appropriations and political will at the executive level. And tort law provides some important public health benefits during the time when we're in a waning phase. And finally, Although I don't think tort law is primarily regulatory, even by design or in effect, it does tend to incentivize manufacturers to improve their products as soon as they become aware of a problem, to let the public know when they become aware of a problem, and to make their products as good as they can be. And that is an invaluable and irreplaceable value of the tort system.
I think it's possible that Rob will be unpersuaded that the tort system is the greatest regulatory scheme ever, and I will probably leave that part of Allison's comments to largely Rob, although I'll have a thought or two about it. I have 3 points that I want to make. The first is I think that while the other folks on the panel have done a wonderful job describing and giving their views of the Supreme Court's critical recent preemption cases, they each, because each is so involved in the process, Allison and Lou advocating on behalf of individual claimants under state law and against claims of preemption. Rob is a leader in the business community on these issues. On the other side, there is a sort of natural human tendency to look out across the crowd and see your friends. And so Allison and Lou helpfully describe the greatest decisions in the history of American jurisprudence as the anti-preemption decisions in Wyeth versus Levine and Altria, and Rob assures us that no, the only decisions that have ever been respected in any way at all are Greier and the Chamber of Commerce versus Brown. And this is something that I do myself when I'm deeply involved in an issue. But I would say there is a great danger in looking out across any given term of the Supreme Court. I don't think anybody would disagree with that. These cases are basically being decided by the same people. They do reflect some changes in circumstances like the administration. But, Justice Scalia didn't wake up one day and go, my God, I really, really, really like plaintiffs' lawyers. That's now, there hasn't been...
We're still waiting for that to happen.
Right, exactly. And it may take a while. Right? So nothing so profound has happened. I would say in particular, while the plaintiff's bar, which is not a term that I use pejoratively, is really enthused and optimistic in the wake of Wyeth, in the wake of Altria, as Lou sort of alluded to at the beginning, the perspective of that bar is, well, it is still the Roberts Court. And that ought to give pause to the idea that something profound has changed attitudinally in the Supreme Court that says, yes, the Supreme Court is now actually much more in favor of allowing these sorts of claims to go forward, particularly because, as I mentioned in passing, there's such a wide swath of Supreme Court jurisprudence that points in the opposite direction and is more directed towards door closing. So it would be kind of surprising that the Supreme Court would pick out preemption law to be more favorably inclined to these claims. The second thing is that I wanted to mention is that while I think that everyone has suggested in one form or another that preemption does turn on Congress's intent, Rob said it expressly. The reality of the situation here is that Congress doesn't have an intent. I mean, if we were just to be honest about it, Allison mentioned in 1976 when this statute was passed, Congress thoughtfully sat there and wondered what it would do as state tort claims. Congress never thought about this any more than it thought about any serious problem, and so the Supreme Court is trying to make up a congressional intent by saying, gosh, if I would really love for Congress to be a sensible group of people, and if Congress were a sensible group of people, this is the system it would have intended to design. And that's a lot of what's going on. Does it make sense to the Supreme Court that it would allow this litigation to go forward or not? This is just how the Supreme Court decides hard cases a lot of the time because it's forced to decide them that way. The third thing I would say is I will pause on Allison's view that, gosh, these sorts of claims are really important, and you shouldn't worry so much about diverse regulatory schemes. I would say that probably the business community is a little bit more concerned with sort of not just different regulatory schemes, but lots and lots and lots of juries. While Allison at one point helpfully talks about the important compensatory role of these lawsuits, she also talks about it as a positive tool of regulation. You know, the funding goes down in federal agencies and like, agencies learn from these lawsuits. But note the dilemma that when you do attempt to regulate through litigation systems, because regulation involves costs and benefits, and plaintiffs' lawyers' job is to do the first part of what Allison talked about. That's get compensation for their clients. That's their ethical responsibility. And so and as litigators, we kind of go to war and we fight and we go and we bring every claim that we can and the like. And that is an imperfect system for regulating. And that's why the more conservative members of the Supreme Court, I think, would be happier with expert regulators, people who know about drugs and devices and the stents that are in their chest, rather than having this dealt with more through litigation.
Well, I'd like to focus on a couple of practical subjects that Tom had said earlier, that the cases that actually reach the Supreme Court are the rare, hard cases, and that the bulk of preemption issues are never going to make it to the Supreme Court and are going to be resolved by people in this room and your peers. I must take issue with Rob's notion that Greier is somehow fundamentally sound law. I think Greier is a one-off. It was a unique case involving a very unusual regulation, and it undoubtedly remains good law as to that one regulation. But I think it's very clear, and if you read the comments even by Justice Thomas in Wyeth about Greier, the idea that the court clearly is uncomfortable with sweeping notions of implied preemption at all, and the idea that they're going to find a lot of implied preemption in the face of statutes that contain an express savings clause that says nothing in the statute preempts state common law causes of action, just strikes me as quite a reach. And I think left on its own terms, Greier survives, but I for one wouldn't be inclined to cite it a whole lot more in cases outside of the NHTSA context.
Lou, I doubt you are citing it anyway.
A little bit, but not usually for its main holding. I also want to reiterate Allison's point about regulatory compliance. One thing for all of you to keep in mind is that the law in all 50 states already takes the issue of federal regulation into account. Under the restatement of torts, under precedent in, I think, every state, the defendant is welcome to admit evidence about his company's compliance with federal regulation. And it becomes the burden on the plaintiff to come forward with some evidence for why that shouldn't be enough. Rob had a slide in which he said, one reason we should have a lot of preemption is because it's not possible for Congress to anticipate future events. Well, the fact that we can't always anticipate future events is a reason why we shouldn't have preemption. I mean, one of the things that the Supreme Court noted in Wyeth is that when a drug goes on the market, it's been tested in a couple of hundred people in a limited clinical study, and a lot of the problems with these products don't even emerge until they get introduced into the market, and federal regulatory agencies can't always keep up. Regulatory compliance allows a plaintiff to sue when one of those unsurprising conditions arises, and allows them to say information that the company learned after it got its agency approval is a reason why the agency approval isn't sufficient and their conduct is still negligent. Finally, I just want to mention a case that we haven't talked much about, which is the Buckman decision. Buckman is another one-off, a case that involved a claim against a consultant who helped a medical device company get approval for a medical device. When that device ended up having lots of problems, the victims sued not only the manufacturer but also the consultant. The manufacturer settled in traditional products liability law, but the case went to the Supreme Court against the consultant on a fraud on the FDA theory that somehow, because the company had misled the federal agency about its intentions, that there should be tort liability, and the Supreme Court quite decisively said no. I think that case, like Greier, is a one-off. It's one that's dealt with its own unique facts, but I think especially in the wake of some losses on traditional implied intent doctrine, we're going to see more and more claims by defense lawyers that what Buckman really means is that plaintiffs can't take issue with anything that happens in front of a regulatory agency. I think that's incorrect. It's doctrinally wrong, but it is an argument that we are starting to see more and more being made, and one that many of you may have to confront. Thank you.
Thanks, Louis. I'll make 2 points briefly. One, let me pick up on the distinction between one-off and general, but not talk about cases, but about facts. I think that one thing that is going on is the courts and the Supreme Court's different perception of compliance with regulatory standards in a one-off fact pattern as opposed to a mass-produced fact pattern. If you say I wasn't driving negligently because I used my turn signal and obeyed the speed limit, and et cetera, nobody's going to say that's fine. The problem that I think a lot of courts have is that they look across mass-produced products, thousands of cases, and they know it's a drug, it's a medical device, it's a car. It's something that's going to cause physical harm and grievous harm in some certain percent of the cases. They say to themselves, to allow any claims to go forward is to allow liability. We don't know which cases, we don't know how much, but if there is not preemption, there will be liability. And so I think one thing you have to look at is this distinction between a one-off fact pattern and a common fact pattern. The second thing, again, I'll pick up on what Tom said a little bit. These are one-off statutes. These are one-off cases. The pendulum is swinging back and forth, and I certainly hope it swings in a different direction in the future. But if you don't look at some of the underlying drivers of the law, you miss where the law is going. Let me give you an example in the First Amendment context. First Amendment has always been under discussion, at least for the last 100 years. The pendulum may have swung back and forth as to having a more robust or a less robust First Amendment. But what you can certainly say over the last decades and generations of First Amendment jurisprudence is it's become more sophisticated. Back in the days of Justices Holmes and Brandeis, they didn't apply the content-based distinction, they didn't apply the viewpoint-based distinction. And if you just look at the law in terms of the pendulum swinging back and forth, pro and anti, you miss oftentimes some of the underlying analysis that the Supreme Court and only judges have to undertake. The last presentation that I made on preemption was just a couple weeks ago for the ABA, and the title of that presentation was Anomalies in the Most Recent Supreme Court Term in the Preemption Cases. And some of the ones that I talked about there, we won't talk about here, all of them, but the preamble statement in Wyeth and the regulations in Cuomo got less deference from the court than mere amicus brief statements in Greier. Justice Thomas rejected obstacle preemption for the first time after 15 years on the court. It's not like the Dormant Commerce Clause where he always had concerns, but for the first time after 15 years, after voting for implied preemption in Brown, he rejected it in Wyeth. Justice Scalia, the justice most confident in Chevron deference, gave little emphasis to fears of litigation abuse and little deference to administrative regulations, not only in Cuomo but in Riegel. Again, Justice Breyer voting against the Solicitor General in back-to-back cases, something he had never done in his first decade on the court. Justice Thomas asking a basic question and implying that the lawyers before him had never given an answer to that question. What is a conflict? At a minimum, we can all agree that there is something called implied preemption. If there is a conflict between state and federal law, that's implied preemption. Even in the absence of any congressional statement, I want to preempt, there has to be some scope for implied preemption in cases of conflict. Well, what is a conflict, says Justice Thomas? Is it physical impossibility? Is it cutting back on the purposes? What is a conflict? Now, that's a basic question, and the fact that as Justice Thomas scanned the briefs in the case before him where he asked that, or scanned the jurisprudence of the court, there wasn't an answer to that question, and there wasn't even a well-framed list of alternatives to that question. That's significant. And so I do agree that these are all one-off cases. I do agree that the pendulum is going to swing back and forth. What I would disagree with others on is this idea that it's the same old, same old. I don't think it's the same old, same old. I think there's a newfound focus on the court and in the bar, and I think it's exemplified by the fact that we're talking about it here today.
Let's open up to the group for questions. Step up to the microphones. We'll take about 15 minutes.
I'd like to key off something Mr. Goldstein said. It seems that in these cases, and maybe in some of the ones we were talking about earlier, in the what is and isn't sufficient evidence to carry a case to a jury, that the tendency is for the jurisprudence to distrust the juries and to constantly impinge on the right to trial by jury. And I'd just like to hear some comments on that.
Well, I think that my friends on the panel may have different views on whether it's good or bad, but I will say that I do think you're accurately describing the Supreme Court's perspective. I think that the court has, and it's very different, whenever you say the Supreme Court, there's 9 different people with a lot of different views, and so you can't say all of them together. But it is surprising when you think about a court that has folks on the left and on the right on it, that there would be on something like this kind of a widespread majority. And for whatever reason, they have become deeply suspicious of what juries do, how they do it, and their effect on positive conduct, whether it's regulation, effectively, by giving damage awards, whether it's the cost of litigation. But that is just a serious undercurrent of 4 or 5 doctrines at the Supreme Court, and that is they want to take these questions out of the hands of juries in particular, and the plaintiff's bar as kind of a cousin of that. And as I mentioned, the Supreme Court's inclination is not actually to take things out of the hands of courts. The Supreme Court believes in courts, although one court in particular, but they are not enemies of the judiciary. They aren't in love with Congress. They think that Congress is a bunch of nincompoops. They aren't in love with the President of the United States. So it's not like they think power should be elsewhere allocated, except that I do think there's a tremendous hostility in the court, right or wrong, good or bad, but that's pretty expansive towards what you describe, and that is allowing things to be decided by juries.
I completely agree with what Tommy said, but I think that reflects actually a skepticism about the civil justice system that actually goes much broader than the Supreme Court. There has been an effort over the past 20, 25 years by Chamber of Commerce and trade groups, the insurance industry, to sort of make us think less of plaintiffs and the plaintiff's bar and the tort system, and I think it's been very successful, and that there's enough bad examples that it was not that difficult for them to do, although there's a lot of good examples also. And just one example of that, we had a client that we were helping prepare for a hearing before Congressman Waxman's committee a year and a half ago, when he was still in the minority, but he was holding a hearing in the Government Oversight Committee. And there was a hearing about preemption, and our client said twice or 3 times during his testimony, "Oh, I'm not in favor of frivolous lawsuits." He was there because his child had been harmed by a drug, and he had a case pending that it was inadequately labeled. But he wanted to make clear, reiterate several times, that he wasn't in favor of frivolous lawsuits, because he had this perception that there were a lot of them out there, even though when something happened to him, of course, his wasn't frivolous, and I don't think he was. My point is just that society in general, people seem to have this idea that the tort system's bad, so it's easy enough to sort of throw it away.
Jeff, something that intrigued me, and I just make this observation, between Wyeth and Riegel, and that is the philosophy of each opinion. Second-year law student can say, well, one's expressed preemption and the other's implied, and that's how we'll cut the apple. But if you read Riegel, They make the policy argument that having 50 different jurisdictions redesign a medical device that may be implanted in one of the judge's chests is not a good idea. I'm putting it in just plain English. Not so much that they don't trust a jury, but that it creates a diaspora of views about what patient safety is that is just not tolerable. On the other hand, in Wyeth, different judge writing, Justice Stevens wrote Wyeth, they're saying that tort law has an additional regulatory function and that regulation alone is not enough to ensure safety. That, to me, is the tension between the two things. And I just share that observation with you. I think the first is correct, but other people who have legitimate points of view may have the other observation.
I completely agree with you that there's language in both decisions that seems completely contradictory, and you can explain it by saying one is express preemption, one is implied preemption, but Riegel, the express preemption case, really does have a lot of implied preemption analysis in it, and I think one thing is that the court didn't want to go there, didn't want to preempt this broad swath of cases on its own. It wanted Congress to give it some language to work off of. And the other is the language that it had to work off of. As I said before, even Justice Stevens, who in 1996 had indicated he thought that cases of preemption under medical device law would be rare, if any. There was just enough cases since then that said requirements equals common law claims equals preemption that he didn't see any way around it by 2008.
I don't disagree. I would only add, though, that I reiterate a point that Allison made earlier, and that a lot of this has to do with who's writing the opinions rather than the substance of the views. Walter Dellinger has a good illustration of this. He says if you're sitting there and the Supreme Court justice starts to announce her opinion for the court that day, and it's a criminal case, and she says it was a dark and stormy night when little Susie was walking home from Girl Scouts, you know that the defendant is in big trouble. On the other hand, if the justice starts the opinion, since the time of Hammurabi, you know that their court is going to rest on some principle of constitutional law. And, so justices write opinions to get to different results. And so I couldn't agree more that the court puts lower court judges and parties in a difficult position when it says yes and no, seemingly in the, very close to the same breath. But I wouldn't infer too much, and I certainly wouldn't infer that the court between Medtronic and Wyeth sort of fundamentally changed its views on that question.
Is a lot of the distrust of juries related to really a split on the nature of what juries do? There doesn't seem to be a lot of distrust in the criminal area. Justice Scalia has been particularly strong in defending jury trial rights and saying that jury trials is most important in practically pretty much all of the court. On the other hand, when you're looking at tort cases, you're looking at a reallocation of resources. And juries may be much less trustworthy in that area. I mean, the common law tradition of juries was really a defense of liberty against the king. When we're talking about tort law in the modern context, it isn't about defense of liberty. It's about reallocation of resources. In England, you've had a dramatic decline in the use of the jury other than in the criminal area. Is that one of the things that's going on?
I have to hark back to something Allison said in response to the earlier question about juries. I think the Chamber of Commerce has done a very effective job of convincing the public that juries can't be trusted when it comes to reallocation of resources. I think anyone who looks at the empirical data, I'm mostly familiar with it in the med-mal context because my firm spends a lot of time looking at challenges to state tort limitation measures. But the evidence of, yes, there are an occasional outlier verdicts, and invariably those verdicts are either remitted by the trial court, overturned on appeal, or settled for a fraction of the jury verdict. But on the whole, I think your instinct is right that the public has a very different perception of juries in the civil context from the criminal context. But I don't think the empirical data provides any satisfactory basis for believing that juries can't be trusted when it comes to civil jury awards.
A comment and a question. With regard to the civil jury, in addition to, or whether or not, publicity and marketing that Allison and Lewis are talking about, I think one of the reasons for doubt about the civil jury is some very prominent mass torts, two in particular, one that involved bendectin, a drug for morning sickness that resulted in the Daubert decision by the Supreme Court. It was a bendectin case, although the court didn't pay much attention to bendectin. And the other is the silicone gel breast implant cases. And in both of those case congregations, if you look at them, there were verdicts both for plaintiffs and for defendants based on the same evidence that existed. And in bendectin and in silicone gel breast implants, the evidence as it developed became more and more exonerative of the drug in one case and the implants in the other. And yet, at least in bendectin, the outcomes, the 50% split, didn't change, which gives you some pause about juries sorting out the difficult causal questions that existed in those two case congregations. I think that gave some pause to juries, to people who look at the jury system and their ability to sort out among them. And I think that's part of the reason for Daubert, which was to say in some cases, judges don't let the jury do that. Tom, there's something you said that I have some trouble reconciling, and that is between Riegel, the medical device case, where expert regulators let them decide about the stents that we all need, and Wyeth versus Levine, a drug case. Same agency, Tom, same agency. And get this, the FDA, when it looks at medical device, new device applications, does not look at whether the design is optimal. That's not part of the review. It looks at whether the device as designed is safe and efficacious. But when it comes
reasonably safe.
Reasonable, okay. When it comes to drugs, on the other hand, part of the approval has to do with the labeling, the warning, and of course, Wyeth against Levine was a warnings case. That same agency, in one case it's not explicitly looking at the issue, in the other it is, 1 year apart, and yet we get different decisions. I guess it's a question, and also, frankly, I was surprised by the outcome in Levine. I expected Levine to come out the other way.
Yeah, and it almost did. I mean, it was very closely decided. Obviously, the FDA, different parts of the FDA, I think it was important to the court that in the drug case, the drug labeling case, the FDA was sort of relatively newly asserting that its labels preempted state law toward actions. And that gave the court the impression, I think, that at the time that the FDA was actually in the business of approving most of these labels, it didn't think that it was displacing the ability to bring a state law suit that would require an additive label. I do think this is an area in which there is a disconnect, and if it could be explained merely as the Supreme Court had completely lost confidence in the FDA, then you would have seen a different result in Medtronic. I still think that, and I will say this was a critical year. The criticism of the FDA in the window between Medtronic and Wyeth really exploded. That's when there were more and more revelations about kind of how business was being conducted at the FDA, and a lot more doubts were voiced about it. So I think that probably plays a little role in the process as well.
I think another thing, which is not a matter of some pure jurisprudence, but when the court was considering Riegel, it had already decided in Lohr that devices that got on the market through this more abbreviated clearance procedure, those claims with respect to those devices were not preempted. And then, so in Riegel, one of the things that Medtronic emphasized is, oh, there's a lot of devices that aren't at issue in this case. These are just pre-market approved devices. That's a very small percentage of devices. Of course, it's also a very large percentage of injuries, but that wasn't what they emphasized, obviously. So there the court could say, all right, we're going to preempt this little swath of cases. Wyeth was a run-of-the-mill tort case. If there had been preemption of that claim, it's hard to see what drug claim could have gone forward, because there was nothing really special about the FDA's review or regulation of Phenergan. So the the court was being asked to do something even bigger than in Riegel and without any statutory language to pin it on. So it was a big step to take.
Well, thank you very much to all of our panelists. We really appreciate it.